Well, our apologies, Miss Dunlop. Despite our best endeavours, we didn't manage to be here by 5:02. But
Well, Mr.
you still have all the time you're allotted, I think.
I managed to make use of the time, milady.
Well, the apologies are due from me. I am the cause of the delay.
Well, I can but accept any apologies. I will begin, if I may, with what I think I have to call some sweeping. And what I'm sweeping up is rather a miscellaneous set of pieces, some of which have arisen in the submissions of my learned friend, Mr. Moynihan. So, if I could mention firstly the question or the topic of guidance, probably in both its senses, guidance from the principal reporter to other reporters and guidance from the national convener to panel members. There's actually also another set of guidance which is on the looked after children regulations. In the time available, I have tried to ascertain some of the factual background on this, and I think it might be better if we presented a short submission rather than taking up time just now trying to explain it all.
Yes, that would be helpful. And I hope you'll be able to agree it with the other parties, and then we don't have to worry about.
Certainly endeavour to do that, my lady. And the other thing to mention is that there are some hard copies of different types of guidance which we have. We have the relevant chapter, chapter 8, which is the guidance to panel members, so chapter 8, which Mr. Moynihan referred, which is called Maintaining Important Relationships. We have some hard copies of that. We have the Looked After Children Scotland regulations as well, and we have the guidance on the Looked After Children Scotland regulations. I'm told that it's difficult to get all this material to my lords and my ladies at the moment because of the laptops being in use, but for what it's worth, if I can tender the hard copies. I think we may be short in terms of number of copies, but if...
Well, it's important that all of this material is supplied, and is supplied both in hard copy and electronically.
Yes, I appreciate that, my lady. And we will certainly do.
But at the moment, it's enough that we know it exists, I think,
yes,
and we can study it at our leisure.
In similar vein, in relation to the matter of contact, and I think in particular, when Lord Kerr was asking about contact at what one might call the very early stages and what the requirements might be for contact as an issue to be considered and addressed. And again, I think rather than take up time, the key provision, which the court will understand having seen it, I think is section 29A, which creates an obligation to consider contact, but how that impacts at the early stages and the various different tracks down which matters can proceed depending on who accepts grounds or doesn't accept grounds and whether they're going off to the Sheriff Court or not, I think are better, again, summarised in a written document rather than from me trying to explain the matter, particularly when I only have an hour. So if I can offer that assistance as well to try and exactly on the terms that the lady suggested, that it would be something that we would show to the other parties so that it could be an agreed document. Much more minor point, but there was reference to the remoteness of the hearings in the XY case. Of course, they're taking place in Stornoway, but simply to respond that the point by reference to which arrangements are made is where the child is. So it's not as though they're taking place in Stornoway for reasons other than that's where the child is and where indeed the family are.
I don't suppose that we thought anything else.
No, indeed.
But of course.
I mean,
Except for me, for You, I think. Is there only one copy of that?
We have more copies of the bulky guidance.
Is there only one copy of that? No?
I was only given one.
Oh,
Oh, right. I don't know why I should have it.
No, I've got that.
You go for it.
Yeah, no, it's this. It's this. It's this.
Oh, no, I haven't got that.
But you're going to give us a note telling us what we should be looking at in this massive document. Yes.
Yes.
Thank you.
Now, and another, in similar vein, another relatively minor point, but there was a question posed and answered about continuity of personnel on hearings. And I'm told that there is a practice of trying to put cases before different members, but equally, if anyone suggests or asks that there be continuity between one sitting of a hearing and the next, in practice that request would be granted.
so why would the basic practice be, let's have a different panel each time?
My understanding of it, my lord, is that, and various other council have referred to their own experience. I too was a reporter, but it was a very long time ago, so I wouldn't want to pretend that my knowledge is anywhere near as recent as Mr. Aitken's. But there always has been a desire to move away from a case belonging to a particular trio of panel members. But equally, the benefits of continuity are obvious as well. So, in fact, I think the commonest strategy for providing continuity is to secure the continued attendance of one of the three. But plainly, that's again something that can be discussed and decided upon in an individual case.
I think what's occurring to us, being of course more familiar with English practice, is that if you're going to have a pre-hearing with directions being given for what's going to happen at the hearing, it makes an awful lot of sense for the person who's going to be running the hearing to be running the pre-hearing.
I can see that, Milady, yes, I can see that. Of course, it depends to some extent on the range of matters which have to be considered at the pre-hearing.
And also, if you've got a hearing that's been continued because of something that's come up in the course of discussion, it makes a lot of sense to have continuity.
I'm quite content in the way that my learned friend Mr. Moynihan relied on it to adduce common sense as a justification for that as well. So, to complete my sweeping exercise, if I could simply say that my page references for the electronic documents are the ABC page references, and that also, because of the pressure of time, if I might sometimes simply give a reference rather than going to the actual document or authority in every case.
Mr. Knopp, can I ask one question at the end of your sweeping before you get into the substance? Mention was made by Mr. Moynihan of Schedule 1, paragraph 7 and 8 about the duty on the social work department to consider sibling relations.
Yes.
Do we have a copy of that in the papers, or is that something that we'll have to obtain?
That's to the looked after children regulations.
Right. So they'll be in the whole of the regulations.
Well, I think the actual regulations themselves have just been passed up. I hope the relevant parts of them.
No, Schedule 1 has not been passed up.
Right.
Care planning has been passed up, but not Schedule 1.
Well, that's certainly something that we need to
Yes.
attend to as well.
Thank you.
Perhaps.
Well, you've spent the first 10 minutes accepting that about 5 or 6 really important documents are not in the bundle. And
No.
you can't make submissions on them orally. They're just going to be in a written note. That's not very good. Is it?
I'm sorry for that, my lord, but the focus of the arguments has changed rather since the first
I
round.
see.
The looked after children regulations were in play actually in the Outer House. They were referred to, and
Very well.
a view was taken that they didn't actually advance matters much, so they rather dropped off the edge at that point, and
I
I
see.
certainly didn't anticipate them coming back again.
Right.
Because we have provided a lot of material, but it's obvious we haven't provided all the right material,
Okay,
which I'm
okay.
very sorry. If I could begin with 2 propositions. Firstly, in the children's hearings for their siblings, the procedural involvement which each appellant has had constituted involvement in the decision-making process seen as a whole to a degree sufficient to provide him with the requisite protection of his interests. I've taken the wording from one of the authorities, SJP against Sweden, which is a recent decision from Strasbourg. It's tab 20. And the paragraph concerned is paragraph 92. The case is page 587 on paper and 1317 on the ABC memory stick. The actual paragraph is at 611 on paper and 1341.
Sorry, which paragraph is it again, please?
Paragraph 92.
Paragraph 92, thank
Which
you.
is at,
1341.
It's actually at 1341,
thank
yes.
you.
It's perhaps in view of some of the discussion this morning, it's perhaps as well to read what comes next. Gosh, in my haste, I have to apologise myself because I find I still have the XY memory stick, and unfortunately I don't have two ports. So if your Lordships and your Ladyships will allow me a moment just to get the right page.
Oh, this is another case talking about parents,
Yes,
the Sweden case.
yes, indeed. Yes, if I could just read on from the wording that I've used in my proposition, what has to be determined, and the court will see that, that's line 4, in fact, of paragraph 92, sufficient to provide them with the requisite protection of their interests. If they have not, there will have been a failure to respect their family life, and the interference resulting from the decision will not be capable of being regarded as necessary. I accept that that is the test. The second of my propositions is this: the fact that a non-parent family member, such as ABC or XY, who is found not to have a significant involvement in the upbringing of a referred child, cannot hold the status of relevant person in a children's hearing about that child, does not represent an incompatibility with his procedural rights under Article 8. I should add that, of course, ABC did not seek the status of relevant person. That was a point that occupied some argument in the outer house. Indeed, at that point, there was an argument about a failure to exhaust remedies, in essence, but that has disappeared. I intend to make submissions in support of my propositions, and I have 6 headings. Some of them, let me reassure the court, are very short. My first of 6 is about relevant persons. Relevant person status is about becoming a party. It is a status which carries duties, primarily of attendance, as well as rights. Rights which include acceptance or denial of the grounds for referral of the child. And this is amplified in paragraphs 4 and 10 and 11 of my case, which is at 139 on the memory stick. It is of great importance to the child that the key individuals in her life are parties in these proceedings concerned with her welfare. They know her best, they can provide information, and they can act in counterpoint to the state. That the legislation makes provision for these individuals to so act accords with best interests at a general rather than specific level. In the beginning, by which I mean the 1968 Act, which started the children's hearing system off, there were children and parents. There is at least at this point in history and science, a natural limit to the number of parents. The reform in the 1995 Act introduced the relevant person, not restricted in terms to parents. It is of its nature, whether under the 95 Act or the 2011 Act, that there can be more than two relevant people. Alongside the importance from a welfare perspective of the participation of these key individuals, there is a second thread to these procedural provisions: the protection of the interests of those with close family ties to the child in the course of actions by the state. This is a protection which antedated 1998, but in the UK finds expression in the applicability of Article 8. The concept of established family life draws on kinship and cohabitation. Indeed, cohabitation is generally essential. And I refer again, without going, to ANIO against Germany, that's ANAYO, which is tab 43, and the specific paragraph to which I'm referring is at page 1266 on paper and page 1996 on the memory stick. In most cases within the hearings system, these two threads, compulsory involvement of those closest to the child for the benefit of the child, and conferment of rights, which will enable the assertion of one's own interests, are knitted together. For those who are parents as a matter of law, that is a clear-cut process. The automatic conferment of relevant person status carries with it the package of procedural entitlements, papers, attendance, and so on. As a consequence of the 2011 Act, this is now also true for others significantly involved in the child's upbringing. They can be deemed a relevant person at their own instigation or on the initiative of the reporter. It is not surprising that parents sit at what Lord Malcolm called the apex of procedural protections. And that is quoting from paragraph 20 of the decision of the Inner House in ABC, which is at 186 on the memory stick. As Milady Hale said in the case of Williams, which is tab 41, when referring to parental responsibility, and this is really very similar to a point my learned friend Mr. Moynihan was making this morning, the starting point must be parental responsibility. All mothers and now most fathers have it automatically. It encompasses all the rights of a parent. The most obvious and fundamental of these is the right to look after and bring up one's own children. So, more completely, that's tab 41, which is at paragraph 38, to be found on 1944 on the memory stick. So parents are at the top, not just because they possess both kinship and cohabitation, but because they are parents. On the other hand, a deemed relevant person could be a relative of any description. In some cases, and my learned friend Mr. Moynihan has given an example, in some cases that person could be a sibling. But it is not every family member, it's not persons as a class, but it could be any family member, depending on their role in the child's life. My second heading is other family members in the hearings system. So there are other family members, those whose role is not such as to render their participation key and confer standing along the way. What of them? Alongside the principal reporter, the position of the Lord Advocate is that relevant person status is not necessary to afford them protection of their position. And indeed, if I understood her correctly, my learned friend Ms. Brabender yesterday was really saying that relevant person status might not actually be very suitable for ABC. Not only is wide conferment of relevant person status not necessary, conferment on those who have established family life, if they wish to have the status, could have consequences which threaten to compromise the benefit to the child which is involved in the idea of relevant person status. One would be multiplying the number of people whose position on the grounds of referral must be ascertained, who possess the right to deny those grounds, to study the papers in the hearing, to appeal decisions, and to call for reviews. It's a front row involvement in the process of making decisions about the child. They would be likely to be a heterogeneous group, siblings, plainly, but perhaps also grandparents. At the moment, protection of their Article 8 rights takes place in a number of ways. Their interest is in maintaining their relationship with the child. And at this point, I would like to go to a case. It's a case of Boyle, which has been referred to at every stage. And if lords and ladies will bear with me, I would like to go to tab 16. It appears at tab 16 and 17 for a reason which is slightly beyond pedantry, but which I'll explain. I think in the eyes of some of my colleagues, not very far beyond pedantry, but it matters to me. So, if I could look at Boyle, which I think actually has been mentioned before, but this is a rather poignant case about an uncle and his nephew. He had ended up being, in effect, a father figure to the boy, and then the boy had been taken into care, and indeed contact had been terminated at a point where the applicant very much wanted to remain in touch with his nephew. So, sorry, it's tab 16, and the particular paragraphs I'd like to look at, I start at paragraph 42, which is 1233, or on paper is page 493.
This was a very long time ago, wasn't it?
Yes, but it was referred to in Lazariva, which is a very recent case. In fact, I think it's 2018. It was referred to by the European Court.
So 16 is the Commission and 17 is the Court.
No, 17 is the report, but the
17 's
report has a mistake in it.
17 is the HRR, is it?
Yes, yes. So exceptionally, I'm going to the HUDOC version, and I will point out the mistake once it's in front of the court.
So we've got at 1233, we've got the EHRR version. You want the HUDOC version?
No.
Yes,
No,
that's right.
17 is the HRR.
Yes, 16 I want to go to.
It's 1223, I think, isn't it?
I obviously
sorry.
wrote down the wrong number,
Must be
MS number.
1223, yes.
1223.
Yes, and the opinion of the Commission begins there, and the first paragraph to look at is paragraph 42, where one finds really the story. He enjoyed a very close relationship with M, and that as a result of the absence of C's father, M was his sister, and C was the child. Absence of C's father, he was in effect a father figure to the boy. The government submit they've never cohabited. The bonds of uncle-nephew relationship are insufficient to constitute family life. And then, just for speed, leaving out the next two paragraphs, but paragraph 45, in these circumstances, and having regard to the absence of C's father, the Commission finds that there was a significant bond between the applicant and C, and that this relationship fell within the scope of the concept of family life. And then 46, where a parent is denied access to a minor child taken into care, there is in general an interference with the parent's right to respect for family life. This is not necessarily the case where other close relatives are concerned. Access by relatives to a child is normally at the discretion of the child's parents, and where a care order has been made, control of access passes to the local authority. A restriction of access which does not deny a reasonable opportunity to maintain the relationship will not of itself show a lack of respect for family life. And the pedantic point is that for some reason in the EHRR version, the word reasonable has been replaced by the word recoverable, which doesn't really make any sense, hence the inclusion of both versions. So I highlight that sentence, a restriction of access which does not deny a reasonable opportunity to maintain the relationship will not of itself show a lack of respect for family life. And I say that it is by reference to that interest that the adequacy of procedural involvement is measured. The petition in ABC is framed around contact. And I mean contact in the traditional sense, albeit there have been some references during earlier stages of the case to residence being in effect contact. It's just 100% contact. But I mean contact against a background of the child being accommodated elsewhere and others having what used to be called access rights or contact. And this can be seen from the petition itself, which is at tab 22. Remedies sought are at page 424 of volume 2 of the core volume. And that's MS 584. The declarators A and B, which are shown there, relate to contact. For XY, we don't have pleadings of that nature, but it is contact that he also seeks. Lords and ladies have heard much of particularly the history of the ABC hearings. We're a bit less familiar with all the hearings that there have been in the XY case, but both appellants have had the opportunity to attend children's hearings regarding their siblings. There has been some legal representation, certainly in the case of ABC. Both have had the opportunity to be heard by means of making representations, oral and or written, in relation to contact. And all of this flows from section 78 combined with rule 60. If we look at section 78 first, which is to be found in tab 2, that's page 39 on paper and 769 on the memory stick. It's really 78 subsection 2. Indeed, both A and B could be relevant, but A, no other person may attend a hearing unless the person's attendance is considered by the chairing member of the hearing to be necessary for the proper consideration of the matter before the children's hearing. And then what must be an alternative is an alternative. The person is otherwise granted permission to attend. Then.
Yes, but there's a big inroad into that in subsection 3, isn't there, Ms. Dunn?
Yes.
Yes,
Yes,
very
there's
well.
an inroad to 2B.
Well, indeed.
Yes, yes.
Yes.
Then the companion provision is Rule 60, which can be found in tab 4, which is page 138 or 868 on the memory stick. So this is procedure where it's a grounds hearing with grounds accepted, or as the hearings in these cases have been, at least the hearings under scrutiny, review hearings, 138 hearings. And we find Rule 60, in particular paragraph 2. I think yesterday when our friend Ms. Brabender suggested that the chairing member had an obligation to summarise. In fact, the chairing member has an obligation to inform those present at the hearing of the substance of any relevant report or other relevant document, and also has an obligation in terms of subparagraph B to take all reasonable steps to obtain the views of the child, each relevant person and any appointed safeguarder in relation to any relevant report, document or matter being considered by the hearing, and what, if any, measures would be in the best interest of the child, and then may invite any other person. So that's plainly a person who isn't the child or a relevant person or a safeguarder. Any other person present at the hearing, as the children's hearing considers appropriate, to express their views on or provide any other information relevant to any matter or action being considered by the hearing.
Is this all post-acceptance of grounds?
Yes.
What's the difference between 91.1 and 91.2? So rules 60 and 61.
Mr. Moynihan is talking about an adjournment. I'll just, if I check. Yes. 91 implies to Mr. Moynihan that 91.2, which is at page 51 in the hard copies. It's for 91. Anyway, the short answer to the question is that 91.1 is where there's an acceptance of grounds and the hearing is going to make a supervision order. 91.2 is that the hearing is deferring a decision on whether to make a CSO. So that's the difference between subsections 1 and 2. I should say, since we are in this area of the rules, that, and obviously this is going to, the lie of the land will be covered in the documents that are going to be prepared, but there is a difference between Mr. Moynihan and myself in relation to, and this is a question from Lord Kerr about shouldn't there be a provision of the nature of Rule 61 about having reports at the very early stages. But in short, the difficulty with that is that at that point, all that there are allegations, undisputed allegations at that, and such papers as there are, for them to be distributed would probably be premature, but I can reassure my lord that the timescales which are involved in sending the matter to the Sheriff Court and having the Sheriff consider the matter are very short.
But as I understood Mr. Moynihan, he was merely accepting that the opportunity for distributing the relevant documents at that stage should exist. I mean, I wasn't suggesting to him that they should be automatically distributed, merely that the occasion for distributing them should arise.
I suppose it depends on what's in them.
But at that stage, the panel may be making an order about where a child should live.
They could be, but it would be an interim CSO.
But it would still be immediate,
Yes.
even if it was interim, so it would interfere potentially with the enjoyment. I'm not saying it necessarily is a right to family life, but certainly with the enjoyment of
Well, possibly, but I will come back to that when I return to the issue of what the interest is and defining the interest. And the other point I would make in response to Lady Arden is that, of course, that's not the situation we're dealing with here.
No,
But if-
I appreciate.
Yes, if we're looking at the entire system, then yes, that may be a possibility. But just to complete the examination of Rule 60, so there is a provision which requires the chairing member to inform people and to invite the expression of views. And when looking at this, I would echo a point made by Mr. Moynihan that, of course, in everything that he or she does, the chairing member and indeed the whole panel is subject both to obligations at common law in relation to natural justice and also obligations under the Convention. There is a mention in, I think it's the written case for ABC, of the predecessor provisions, or of what are said to be predecessor provisions, but these were provisions in the 1995 Act of considerably less scope. There was simply a provision in section 43, subsections 1 and 3 of the 1995 Act for attendance by someone whose presence was permitted, and that's tab 1, page 10 in the paper, or 740 on the memory stick, and then it was added to by what was then Rule 13D of the 1996 rules, that's tab 5, which is at page 185 or 915 on the memory stick. But that was a very basic rule about someone attending if permitted to do so. So there was no counterpart to the obligations that one sees in Rule 60, and indeed Section 78 is an altogether broader provision as well. And as my learned friend has pointed out, Mr. Moynihan has pointed out, no doubt influenced by these litigations, invitations to people to attend are now being sent. There is also, in this discussion of others in the hearing system, other family members, the matter of parental attendance. Other parties represented point out that a parent doesn't have the legal right to represent a child entitled to represent himself. That's true, but the existence of parties represented who are pursuing interests in congruence with those of the sibling is not an irrelevant factor. In these cases, that factor is principally of importance insofar as the appellants were pursuing family reunification. I suspect there are really 2 points here. If we are talking about a right to participate in the process to the same extent as parents to dispute the issue of where the sibling is accommodated, then congruence is relevant. If the need is only for involvement to promote contact, then, as is suggested in some of the written cases, there could be conflict. But even there, parental involvement is relevant in assessment of what procedural rights demand. And I'd suggest that parents are more likely to be in favour of their children who want to see each other maintaining contact than they are to be saying that 100% of the contact available must be afforded to them. My third heading I've called abstract review. There has been in these litigations, and indeed in some of the others which have dealt with this issue, time spent conceiving of other factual situations. Thus, for example, the case of Lazareva, to which I've already made reference, which is at tab 47, Lazareva against Ukraine, which is a decision from April 2018. That's tab 47, which is page 1351 in the hard copy and 2081 on the memory stick. Paragraph 65 of which refers to the Boyle case, when your ladyship asked me earlier, isn't Boyle rather old? That's where the reference to it is in 2018. In that case, there was an aunt who had appeared and was wanting to offer a home to her nephew. And her wishes in that respect had been dealt with perfunctorily. And the finding was that what had happened, because she didn't enjoy established family life with her nephew, it was a category which one sees in a few of the Strasbourg cases of intended family life. But how it was actually characterised was an interference with her right to private life under Article 8 rather than family life. The hypothetical aunt has featured in arguments at earlier stages, certainly in the XY case, someone who has perhaps arrived back in Scotland from overseas intending to care for a niece or nephew. Such a person might have intended family life, and indeed in the Anayo case, which was one that also was very non-mainstream in that the applicant was the father, I think of twins actually, but the biological father, but not acknowledged as the father. These are cases which are difficult. They are non-mainstream, either people who don't have any current contact with a child or people whose biological relationship is not acknowledged. In Anayo, obviously, that's tab 43, the applicant was a parent, and the court didn't rule out that intended relationship, the relationship he wished to have, constituted family life. But their reason for not ruling it out was that because in any event it would be private life, even if not family life. Again, in this sense of what ifs, I'd mention also the V case, V against locality reporter, to which the court was taken yesterday. It appeared to be being suggested that what looks a sensible and sensitive decision would somehow be barred under the current legislation. I say to that, not necessarily. In the V case, and I should have given ladies and lords the tab number for the V case, it's tab 15, But again, without going to it, in the V case, I did note finding, in fact, 17, which is at 1212 on the memory stick, that V had had a caring role towards her little brother and provided support for him. Just because one can conceive of situations which appear hard to fit into the legislative framework, one is not justified, in my submission, in basing a finding of incompatibility on that. And I, in my written case, I've urged the court to follow an approach similar to what was said in Christian Institute at paragraph 88. Christian Institute is tab 8, and the paragraph concerned is at page 287 on paper and 1017 on memory stick. And I appreciate that Christian Institute was an ab ante challenge to legislation, and the context of the remarks is a proportionality argument, but my point is the same, that ultimately the question becomes, is the legislation capable of being operated in a manner compatible with convention rights? And my answer to that is yes. I can't make a submission that there is nothing in the system which could be improved, or that there will be and have been no human failings in how it's operated, particularly perhaps when viewed through the prism of the experience ABC had in September 2017, given that we know more about that than any individual experience of XY. But it is also the case that this is an opportunity for this court to express its views about rights which need to be protected and respected within the system.
In the Christian Institute case, paragraph 88, the court said that an ab ante challenge faces a high hurdle if a legislative provision is capable of being operated in a manner which is compatible with convention rights, in that it will not give rise to an unjustified interference in all or almost all cases.
Yes.
I mean, do you make the claim here that this legislation can be operated in a manner so that it will not be incompatible in all cases?
If operated properly and in a convention...
Sorry, I put that wrongly. Will not give rise to an unjustified interference in all cases.
That would be my position. It would not give rise to an unjustified interference in all cases.
So your submission is that the legislation is sufficiently flexible and open-ended to allow an unjustified interference to be avoided in every circumstance?
Yes.
Yeah. So, okay.
If those who operate it are bearing in mind all the surrounding obligations to which they are subject, yes.
And if the law or the rules are accessible to those who wish to operate them?
Yes. And there will also be guidance.
Yes.
The court has seen that there's quite a lot of guidance, and it...
But how much of that guidance is accessible to those who use the system?
It's had to be squirreled out to a certain extent in this case.
It's guidance which is issued to panel members, the chapter about the importance of sibling relationships. And I should mention that there are statutory obligations in relation to training.
Yes.
So,
But my Lord's question, I think, was probably more directed to guidance for those who might be affected by the reporter's decisions. In other words, siblings, grandparents, and so on.
Families generally. I mean, is there nice, simple, everyday information available to people who might be affected by the children's hearing system?
I would hope that there is. I'm certainly not going to say that I know the answer to that, milady, but there are a number of, I'm sorry, Malerian Jr. is trying to tell me something. There is. Yes, I'm told that there is, but that was what I was going to say is that there are a number of different sources as well, and actually what I am coming on to look at is a report from Who Cares Scotland, which was prepared on DEF. So they're an organisation which becomes involved sometimes in these very difficult situations.
Well, could I add that guidance to the court shopping list, please?
Well, it's information, isn't it? It's information rather than guidance.
Yes.
Yes, I mean, the things appear on the website, but I accept that it's not a complete answer for every family to say there is material on a website.
No.
I accept that.
I'm sure the Wi-Fi in Stornoway is wonderful.
Well, there is some sort of programme of rollout of 5G, which I think probably means it's better than one might expect.
Yes.
Anyway, it depends on one's starting point of expectations, I guess.
Could I just ask you another question? It's prompted by your citing cases about other relatives. It's a very standard practice in local authorities in England, not invariable, but often done, to explore the possibility of a placement with the family, with the wider family, kinship care,
Yes.
rather than foster care or institutional care. We hardly ever use institutional care, but rather than foster placement, before deciding that that's not going to work. Now, in English law, such a placement can be handled in a number of ways, one of which is by making a care order and then placing with the family under the care order, but another of which is making an order that the child is to live with the particular, it's often an uncle or aunt, or sometimes grandparents. Now, as I understand the Scottish position, the children's hearing could, of course, say that the child is to live with a member of the family as part of a compulsory supervision order, but they could not make what I think you still call a residence order in favour of the relative. That would have to be done in the sheriff's court. Is that right?
I'm not sure that it isn't, lady, but I'm nervous about giving an answer. If your ladyship would allow me a moment to.
Well, no, just park the question, but I think it's relevant to the point you're making. And what I'm getting at is, yes, we're talking about siblings here, but we do have to look at the Article 8 friendliness of the system generally, and other relatives are an important feature in the care system in England and Wales, and it would just be useful to know. I suspect Mrs. Scott does know, but I won't ask her, because I'm asking you.
Yes, indeed. Yes. That's something, in practice, I know that it happens, but I appreciate the thrust of your ladyship's question. I have, at this point, I'm turning to my fourth heading, which I've called the interest at stake. I have already said, particularly in reference to Boyle, that the interest being protected for these other family members is an interest in maintaining the relationship.
Well, that was partly why I was making the question, because the interest of a grandparent or an uncle or aunt who wants to offer a home to the child is more than maintaining a relationship. It was that statement that prompted, plus
Yes.
the reference to the other cases, which you regarded as
again,
outliers. Yes.
Neither of these cases concerns somebody wanting to offer a home. I mean, I
know
have
that,
asked,
but we have to test it against the wider context of.
well, I suppose the difficulty with that, milady, is that the preparation has concentrated on the circumstances of these appellants
Yes.
rather than investigating what goes on in other situations.
Yes.
But I have previously asked about a collateral relation who wishes to be considered as a carer, and been told that social work practice would always look to consider that person's suitability. But quite what the whys and wherefores are. I mean, it also reminds me of something that arose yesterday about making a supervision order and including the name and address of foster carers. And I'm told that there are regulatory requirements in relation to that. The hearing must be satisfied of a number of different matters before it actually can go ahead and say, you will live with Mr. and Mrs. Smith. That's a slightly different point. It's just that it popped back into my memory when your ladyship asked the question. I need to say that it is not accepted by the Lord Advocate and has not been conceded at any stage that taking a child into care for the promotion of that child's welfare represents in and of itself an interference with the Article 8 rights of all who have established family life with that child. Now, there will be family members who cohabit in ordinary circumstances with the child. They will usually be siblings, but siblings, as my learned friend alluded to this morning, siblings itself is not as clear-cut a category as it might at one point have been, because we could have full siblings, half siblings, or step siblings. There could also be grandparents who live with the family, and indeed other family members who happen to live part or all of the time with the child. At this point, I need to go to the concept of the core family unit, which my learned friend Ms. Brabender mentioned at the outset of her submissions yesterday. This is, I'm fairly sure, a reference to paragraph 38 in Principal Reporter against K. I do want to look at that. It's tab 11, which is page 333 on paper and 1063 on the memory stick.
Which paragraph?
Paragraph 38, which is page number 345 on paper and MS 1075.
Thank you.
Now, there have been a number of arguments in Edinburgh about, we know the authorship of this paragraph, and there have been questions in which people have suggested, myself included, what is meant by the core family unit. But conscious of...
I believe that this was a joint judgment
Yes, there's
between
been
myself and Lord
very
Hope.
appropriate reference the whole time to Lady Hale's judgment. But in fact, you won't allow us to forget the great Lord Hope.
Well,
This was a joint judgment.
I know that, but perhaps unusually in paragraph 1, which we now have to go to on MS 1065, it says, as the reader will discern, Lord Hope has taken the primary responsibility for dealing with the first issue in paragraphs 2 to 31, and Lady Hale has taken primary responsibility for the second in paragraphs 32 to 69. So that rather nails it.
I'm sorry.
Yes, back at paragraph 38, the reference to core family unit. I say this obviously with deference, but in my submission, when one reads that paragraph, what your ladyship was talking about was the child and his or her parents. If I could quote another famous figure, in law, context is everything. My learned friend said yesterday that the family is before the hearing. It's DEF who's before the hearing, or LM, AM, or EM. Of course it affects the others in the household. And of course DEF matters to ABC. It looks very much as though ABC matters to DEF. And at this point, this is a digression, but I think it's important because Lord Wilson asked yesterday about the conduits. There is a very full report from Who Cares, which I mentioned earlier, dated June 2017 when DEF was 6, and that's at MS 427. And it really, in quite some detail, it describes the engagement which Ellie Barrow of Who Cares Scotland has had with 6-year-old DEF. And it certainly covers his views and feelings about his family. In other areas of law, one could
What was forgive me, I keep asking you questions, but what was the context for the preparation of that report, which I've read?
Well,
but I can't remember what the context was. Why was it prepared, and for whom?
Unfortunately, there's nothing more specific than that. Advocacy is offered to support young people involved in the hearing system, and someone must have, I don't know whether family or a social worker, but someone must have made the connection, or it could even have been school, I suspect. Who Cares has a welcoming website, but again, I don't imagine that at 6, DEF did it all himself. Someone must have put them in touch. I'm afraid I don't know who.
Thank you.
In other areas of law, one could quite easily speak of the core family unit and mean a paradigm of both parents with their young children all living at home. But there are many different types of family and different types of arrangement. There may be people with whom the child sometimes lives, as in Boyle, where the nephew spent every weekend with his uncle, or a child may spend every weekend with a grandparent. If I am one of those people, having the child in my home with me is likely to be a crucial factor in my life. Taking a child into care is likely to effect a reduction in the amount of contact which can be enjoyed for all those with established family life with the child, not just those who live with him or her all the time. In the Strasbourg cases, termination of contact has certainly been regarded as an interference with Article 8 rights, but as I've said, the right is better characterised as a right to maintain one's relationship with the child, a reasonable opportunity to maintain the relationship. If one looks at this question of what actually is the interest, if one looks at it from another angle, in the ABC case, the hearings complained of in September and December 2017 took place when DEF had already been in care since June 2016. Ladies and lords will recall that the timeline was that both boys were taken into care in June 2016. They were not accommodated together, about the reasons for which we know nothing, and then ABC returned to the care of his parents in July 2017. When analysing whether those hearings, by which I mean September and December 2017, restricted contact, one needs to identify the baseline. The baseline at that point was that DEF was being looked after away from the family home for reasons which are not before the court, but which one has to take were judged to be in his best interests. Those hearings, the hearings of September and December, stipulated for contact as a minimum. And there is an example, one of the supervision orders is at MS 0423. Sorry, I don't have the paper number of that, but I mentioned this, and this fourth heading, to refute a point which is made in the written case for AM that everyone accepts that the taking of DEF into care was an interference with the family life of all other members of the family, or at least of ABC and XY. My fifth heading is points raised by others, including, I'm sorry, this is a very clunky heading, but points raised by others, including the mandatory considerations to which others have made reference. ABC's father and mother are interveners. Both discount their own presence at hearings as relevant to the degree of procedural protection required by ABC. Now, I've already said that it's not irrelevant, and I dispute the proposition in AM that the principal legal question is whether Section 81 can be construed to cover the appellants. The principal legal question in my submission is the logically prior one of whether it requires to be so construed, which takes us back to what Article 8 requires. I need to take this fairly short, but the mandatory considerations are the need to safeguard and promote the welfare of the child, Section 25, and the views of the child, Section 27. Both these provisions use the formula of when a hearing is coming to a decision about a matter relating to a child. Welfare is not the determinant of who has relevant person status. And I agree with YL, intervener, the mother, I agree to that extent. Neither is the views of the child, or neither are the views of the child, a determinant. Views in my submission cannot veto, and that's the point that Lord Malcolm makes in the CF against MF case. I wonder, given that time is very short, I did say I would be going to it, but if I could simply give the references. Lord Malcolm
6
has...
minutes over already.
Oh, I'm sorry. Lord Malcolm has a careful discussion of these issues. It's tab 7,
No, she's not.
paragraphs 43 and 47. As far as LM is concerned, it's very hard to say that one wouldn't take into account her feelings. For AM, she, and we've heard she would like to have,
I see.
she would like to have XY as a relevant person. Can I simply mention in this context Rule 11, which I think hasn't been referred to, but Rule 11, which is tab 4, page 89 on paper, or, sorry, page 95 on paper, page 825 on the memory stick. Rule 11 entitles a child in the hearing system to have legal representation and to have someone else. So it does appear that a remedy for AM, who wishes to have her brother with her at hearings, would be to use Rule 11 and say he's my Rule 11 representative. Now, if I can take short the parliamentary material which has been put in issue from the time of the passage of what became the 2011 Act. In the sixth respondent's memory stick at page 0700, Parliament is discussing a proposed amendment to the definition of relevant person, which would have made relevant person status open to someone who should, as a result of a family connection with the child, be involved in discussion at the hearing. That was rejected, and there is reference to the potential for that to result in multiple relatives, such as grandparents and siblings, being involved in a hearing. And there's reference to cost. I say three things about that passage. One, in my submission, the Minister appears really to be talking about a desire to avoid groups which could involve large numbers of people with relevant person status, in that there's potential for many people with a family connection to assert that they should be involved in discussions. Secondly, 3 weeks later, the amendments forming Section 126 were brought, which were those dealing with provision for a contact hearing. And thirdly, I don't rely on this material because it is rather garbled as to what are and are not relevant considerations in formulating the definition of relevant person. Finally, I should talk, and this is my sixth heading, I've called it outcomes. Plainly, I am urging the court to refuse the appeals. To sum up, I would revert to what I said at the start, that the procedural involvement in both cases fulfilled the test required for participation for these two appellants. The Section 78 route allows for a divide between relevant persons and others with Article 8 rights. There was a discussion yesterday with Lord Wilson about blanket notification. This is an odd thing to say, but a blanket would be a blunt instrument. My Lord used the example of a child aged 3, and my learned friend Ms. Brabender responded by mentioning a child aged 12. But as we've seen, children much younger, children 7, 8, 6, have views, but that they should receive intimation of hearings about their siblings. Article 12 of the CRC says that adults must hear their views, but it's actually the weight to be given which is age and maturity dependent. And there's also the point that if you're intimating to all siblings, it's very hard to resist the need to intimate to grandparents and others with whom the child spends time. It can be hoped that a social work report will identify those who don't appear to have a significant involvement in the child's upbringing, but from whom representations might be required for their own sake. It is difficult for me to propose what the remedy should be if this court thinks thinks provisionally there is an incompatibility, or thinks there is an apparent incompatibility. Our friend Ms. Brabender says that provisions are incompatible and refers to sections 281. In my submission, it's not actually been demonstrated that these sections are doing anything wrong. It's rather a suggestion that the scheme is incomplete. My question really would be, well, what is the defect that the court has identified? And to carry on the metaphor that was used yesterday afternoon of firing guns, my problem is I can't see the target. In S against Miller, which is tab 13, and that was about legal aid in children's hearings, the court was considering a declarator of incompatibility, but there seems to have been an agreement among parties as to how to fix the problem the court had identified, which avoided the need. So if this court were to conclude that there is, at first blush, an incompatibility, then the position of the Lord Advocate is that, in broad terms, the approach taken in Christian Institute should be followed. That's tab 8. Although there the problem was that the provisions were flawed, in my submission that doesn't render the the template unusable, this may be an opposite problem, but I would make reference to paragraph 109, where the court said it would invite further submissions. In a sense, that might preserve for another day the option of reading down whether something is possible. But that would be a much easier option to consider once all are clear about what any defect is. There are a lot of moving parts. So unless, and with apologies for having overrun.
I'm not sure that you have overrun, because as you only started at 2 and you were supposed to be 2 till 3:15, I'm not sure that you have.
Well, I think I have actually, but that's the discussions among parties, which that would just take up more time if I were to try to explain it. So
yes.
perhaps I should be apologising to my colleagues. So for those reasons, I would urge the court to refuse the appeals.
Thank you, Ms Dunlop. Thank you. Ms Charteris? Now, which of you is going? You're going first, are you, Mr Mitchell?
My Lords, I go next. I should say, so far as timing is concerned, there were a lot of different draft timetables floating around. But certainly the timetable which I had was that after the Lord Advocate's address, there would be 15 minutes from me, 15 minutes from Mr Setright, and then there would be replies. And so I think with respect, we are at the moment rather overrunning, but I don't want to complain about this and make that overrun more. I can be fairly short, I hope. I appear, as you know, for LM, who is in court. She's the young lady sitting there behind Miss Brabender, and has been taking an active interest in this litigation throughout. She was a litigant, of course, in the Sheriff Appeal Court. She has found this very stressful, but she has nevertheless wished to come along to the extent of making up her notes to give them to me at lunchtime and so on. She is at the centre of this case. There's been an odd, as I put it in my case, tacit assumption throughout this that this is all about the rights and interests of the apparent relevant person. It is not. She is at the centre. You have my case. You have, in particular, on that, the final page, of which LM is the author, which I commend to you. You also have, as a further supplementary document, which went in late, the most recent children's hearing determination from February. I don't propose in the time available to take you to that, but it's a determination which describes the fairly up-to-date position, although there have been changes since. Now, in the time which I have, I'm not going to go back over my case. My first point is a short one. It is that Mr. Richardson was entirely correct in his core proposition, as he put it, his single proposition, that section 81.3 must fall to be construed so as to give due regard to the views of the child. He explained why he took that position by reference both to section 27 of the Act and to Article 12 of UNCRC. There may not be much distinction in the language, but like him, I would prefer the due regard formulation. And I need not repeat his analysis. A matter which I would add, however, to, because it didn't really emerge on his, is this. Under this Act, a child may be up to 18 years old. His client is, of course, 15. Mine is 16, and potentially subject to the system until her 18th birthday. And that creates particular nuances in the question of how one might have regard, proper regard to her views. Looking, I now pass on to the facts of her case. What my ladies and my lords have here on the facts of the case is a problem as to who might be a relevant person. which commonsensically admits of only one possible sensible answer, which is due regard to the views of this young lady have the consequence that he cannot, her brother or anyone else, cannot in truth be allowed into this process unless she is willing to consent to it. Now, she has stated her views. To some extent, she has given reasons. But I emphasize, as has been said before, that it would be absolutely wrong to oblige a child in this position to justify their reasons. And to do so could fairly obviously be destructive of family relationships and of her best interests. But you see enough of her position to see that this is a thought-through and sensible position that she is adopting. But it's not my proposition that it should be acceded to because it is sensible and thought through. My proposition is that she is the judge of this. If she was not subject to the children's hearing system, if she was one of the friends that she has, who she describes in her note, it is impossible that she could be in the position of being forced to explain to a legal forum why it is that she does not want any particular form of further contact, or to lay out her private life in reports in front of other people. In an ordinary context, a child in Scotland ceases to be subject to any possible order for residence or contact at 16, and quite right too. But even before then, as in England, the court will rarely fail to defer to a sensible 14 or 15-year-old who states a clear view as to these matters. She has however, two broad areas of concern which are articulated in her case. I can touch on each of these very briefly. First is privacy and confidentiality. The second is the cri de coeur in her statement, that she just wants to be treated, as she says, like other normal children. The second of these is the shorter point. Other children, even below the age of 16, do not find their siblings elbowing into their lives, insisting upon seeing their school reports, their health records, descriptions of their relationships with their friends, and analysing them. Their parents may well do this, as Mr. Moynihan pointed out. It's a strange parent who then takes these off and waves them at Big Brother or Big Sister. It is, or ought to be, seen as exceptional in the context of children who are teenagers to allow siblings into this setting, unless, as in AM's case, that is the wish of the child. Equally, if that is the wish of the child, it's not for me to argue AM's case, which Mr. Richardson has done, but it seems extraordinary that one could get to a legal resolution of this, which refuses her the right to have her brother there if she wishes him. So much for the point about normal children, to use her word. Secondly, privacy and confidentiality. As has been brought out very fully in the arguments for the appellant, the consequence of relevant person status is that the child's entire life is laid out in reports before the relevant person, subject only, and I'll point at this very shortly, to section 178, which is, I'll be saying, is a quite inadequate protection. These are fundamental rights of the child. You see the authorities on this. we have the GDPR, is in the, I think, the second volume, and I don't propose to take you to it in the time available. The child has a fundamental right to regard these matters as being private. And as the quotations and references I gave in my case demonstrate, it is not upon her that the burden lies of arguing this. The burden is upon the person who seeks to argue that they get access to this material, to demonstrate how and why. And that can only be done at highest for a position, anyone in a position of the appellants, by demonstrating that that is something that is truly necessary for their own rights. Miss Scott, in a line, just tossed this aside by saying, well, GDPR doesn't apply because we're looking here at a legal process in children's hearing. With great respect, that is a howler. The GDPR applies in the context of such a legal process as it applies in all other contexts. And you have the references in my case. The difficulty that the relevant person argument has is that it says that there's an a priori right to get in before the person is a relevant person. Section 178 was pointed to, and that is no protection to the child. The difficulty that we have on that, and I think this is the only document in the authorities that I propose to refer to. Section 178, on the memory stick in XY, is page 333. It's in tab 2 of volume 1 of the bundle at page number 75. Once somebody has the relevant person status, the thin protection available for the child is that the children's hearing need not disclose to the relevant person information if disclosure, putting it shortly, would be likely to cause significant harm to the child. But the person has already got into the status. They've already got this bundle of rights. This is one of the reasons why the flexible approach put forward by Mr. Moynihan works. Using Section 178 reverses the onus. It puts the burden upon the child to persuade a third party that significant harm would be caused by a revelation of her recent health records or something of the kind. That cannot be a proper approach. We are not looking here at the rights of criminal defendants, but Article 6 rights in a court process. We're looking at a question of whether the sibling should be allowed in to the system in the first place, bearing in mind that this is the consequence. And if the child is left having to persuade the third party children's hearing under Section 178, then she has not been given her fundamental right to privacy and confidentiality. The flexibility which is implicit throughout the system, which allows people to come along when they have something to say, is decried by the appellants because they say it doesn't give this bright line, hard-edged regard for their rights. And in saying so, we don't hear a cheep from either appellant about the rights of the child, who should be at the centre of this, which can only be protected by flexibility. If one keeps the child's position to the fore, And if guidance is issued by all concerned in a proper way as to that fact, there is nothing systemically wrong with the workings of the Act. What we do, however, have is a problem. If one looks at section 81.3, and you won't want, I think, to look back at this because you'll have its language fairly firmly, that section 81.3 defines a group of people as potentially subject to, as potentially the subjects of relevant person status. And we have this argument about who should be in that group. But then the section assumes, on a strict reading of its language, that any member of that group, whatever it may be, must get relevant person status. And then if they get the relevant person status, they must have the entire suite of rights described by Ms. Brabender. Now, with great respect, this can't all be correct, because what that means is that every sibling can come in, every grandparent. In LM's case, something that happened was that after XY got knocked out by the panel in 2017, one of his brothers came along and then claimed relevant person status. He was knocked out, refused this. Then another brother came along. Every time in this we have a stressful hearing. But on the appellant's theory, they're all entitled to it, and they've all got a conceptually separate interest to maintain. This cannot be correct. And we come back in my submission to a general reflection that on any view of section 81, there must be more flexibility. Now, I have given in paragraphs 10 and 16 of my case some possible recastings.
I'm sorry, Mr. Mitchell, but according to the timetable which I was last given, you and Mr. Setright had a quarter of an hour between you. I know that you think you had a quarter of an hour, and I've allowed you quarter of an hour,
Yes.
but you've now gone on over quarter
I'm
of an
very
hour.
sorry. Clearly, somebody gave a timetable in that case to the court, which was very expressly rejected, both by Mr. Setright and myself. And I don't know who did that, but
Well, I'm
we
very
insisted
sorry
on-
about
yes.
this. I've
I
been
will-
given two inconsistent timetables,
Yeah.
and I was going by the second of the two because that was the one that
Well,
showed Mrs. Scott on her
There's no
feet
point
first thing this
examining who
morning.
the guilty person was, but anyway, that was our impression. I think you have my points, and you have my
We do
case.
indeed have your
Yes.
points, Mr. Mitchell, and they've been very eloquently made, for which we're most grateful. And I'm sure your client behind you is also grateful to you for the way in which you've put her case. I should make it absolutely plain, I hope she understands, that even though we have found certain aspects of how things have gone over the hearing amusing, that does not mean that we don't take her case very seriously indeed, and I hope she understands that. Yes, Mr. Setright.
My ladies and my lords, for the avoidance of any doubt at all, we were given 15 minutes. As very much latecomers, we were grateful for it. We were given exactly what we asked for.
Well, nobody gave you anything because the court was not consulted about the timetables.
It is my thanks to my learned friends, because that 15 minutes was carved out of no space whatever. And so it's not at all right to say that we've argued the toss about that. 15 minutes is what we expect, and 15 minutes, my lady and my lords, is what I'm going to take. Can I start that period with an apology for the extreme tardiness of the involvement by the safeguarder in this appeal. Partly that is because she had difficulties in arranging funding, comes from the Scottish Government, but partly she simply takes responsibility for that and therefore apologises. We're grateful to the court for its forbearance in tolerating a hefty bundle of authorities which isn't coordinated, which isn't helpful, we know, and a written case which came in late. And I'm grateful to all of my learned friends because the safeguarder, having come very late to engagement with funds, found the cupboard bare of specialist Scottish silks, perhaps my ladies and my lords need only look around this court to see why, and took the low road to English representation. We've been assisted very greatly in our disadvantage there. My ladies and my lords, what we can't do, couldn't do in the written case without going out of bounds, can't do in 15 minutes, is to give a third version of the full legal argument in opposition to the appeal. We have indicated that we are in alignment with the submissions made by my learned friends on behalf of the principal reporter, and indeed we find ourselves in alignment with my learned friends on behalf of the Lord Advocate. We've provided in our written case some further material, and perhaps reflecting the approach of the safeguarder, that tends to emphasize the United Nations Convention on the Rights of the Child, which we've provided in long form so that the court, which will be familiar with it, has it to hand. We've also emphasized points relating to welfare and points relating to disclosure, both of which, from the particular standpoint of the safeguarder, are important. But subject to the court's view, such time as I have left may be best spent in addressing the court on safeguarders and the safeguarder, so that the court may have any questions in its mind answered, I hope, about how that particular piece of the Scottish system works. And with respect to the remark of my Lord Wilson, how we say the safeguarder is one of the conduits by which a fair process is established, and persons are fairly heard and have a fair input, notwithstanding any criticisms that may be made about the structure and operation of the present law. So may I turn to those matters, and perhaps the first thing that I should do is to indicate that in our hefty volume of authorities, we provide the statutory basis in tabs 1 and 2 for the appointment, and 3, I think, for the appointment and functions of safeguarders, and perhaps more interestingly for the court, at divider 4, we provide the government publication Practice Standards for Safeguarders, which sets out with rather more coloration what the nature of the role is, and what the qualifications and requirements are. And rather helpfully, and it's going not only to be tedious for the court, but eat into my time if I take your lordships and my ladies through it in detail, but it does actually indicate the statutory basis and the basis in statutory instruments for both the appointment and the guidelines. Also contained within this document is a framework of practice standards and a route by which safeguarders are held accountable to those standards. What I should do, I think, is to take my ladies and my lords to MS 0290 of our authorities bundle, where is provided under the heading Child at the Centre that a safeguarder will safeguard the child's interests through his or her practice, participation in process, and influencing decisions that aim to lead to better outcomes for a child. And then that is set out in more detail in a way that is familiar to any lawyer who is familiar with the general approach in children's cases. The methodology how is significant. The safeguarder will actively seek the views of the child. The child's participation is encouraged where possible to inform the safeguarder's recommendations, each child individual, and then right at the bottom of that section, assessments and information provided by others. And we say that others is a very wide, indeed it's an unrestricted group, including, well, that word in a document written probably with lawyers in mind, at least in part, is not exclusive. It includes parents and carers and representatives from services and agencies involved are considered in helping to inform the safeguarder's communication and representations. The safeguarder, this safeguarder, happens to be a qualified practicing solicitor. She has been a safeguarder for 10 years, appointed in 2009. A safeguarder is an appointment to an office, and it is combined by this particular safeguarder, not untypically, with the continuation of her practice as a solicitor in private practice on Stornoway. There are on the island 2 safeguarders, of which she is one. My ladies and my lords heard statistics as to the number of public law children's referrals in Scotland. We are instructed by the safeguarder that there are 1,200 instructions of safeguarders per year. So my ladies and my lords can see that a very small proportion of the cases involve the instruction of a safeguarder. As to training, there is a national training program for, and I should say that this safeguarder, she sits behind me, having come down from Stornoway for this hearing, it does about 10 cases a year. So far as she is concerned, and although this is little better than anecdotal, I must try and provide the best information I can. She is in no doubt at all that the position of siblings will come under her remit, and that she regarded this particular appellant as being in her remit. She met the appellant on at least 10 occasions, and she can confirm that with regard to this family, since her appointment as safeguarder, there have been no less than 40 hearings. And
I'm sorry, how many?
40. I cannot but remark that tends to emphasise how very different and distinct the Scottish practice is, and how it's a lesson to this team to be wary of trying to make comparisons with English practice, which is a very different animal. Though we have endeavoured to provide a few comparatives, no time to deal with those for this court in our written case. My ladies and my lords, ultimately, so far as the safeguarder is concerned, it is her obligation to provide a broad canvas overview and investigation. She put in 2 reports. No one has called for those reports. No one's directed them to be admitted into these proceedings. That she is certainly keen to put forward the views of children and others concerned, but ultimately it is best welfare interest that she is also required to give a view upon, and she does. There is regular training for safeguarders, and she undergoes that. So far as the individual children in this case are concerned, what this court has not done is to go in depth into what happened at hearings, and that is not, we suspect, remotely appropriate at what is a hearing on higher principles in a reference specifically to this overarching court. But one matter must be updated and corrected, because my ladies and my lords were told about EM's view, as reported in our written case, very, very recently, indeed since the written case was finalised. EM has come out of foster care and into the parental home, and at the same time, the safeguarder has been told, EM has a changed position and now supports, as it is put, XY becoming a relevant person. The safeguarder faithfully reports that and records it, but her view of EM's best interests remains unchanged, and she observes, not rocket science here, my ladies and my lords, that children's expressed views may sometimes be influenced by environmental and personal factors. And she has a particular degree of skepticism as to the degree of understanding in EM, the context of a relevant person, which features in EM's views as retailed. But there that is. The safeguarder holds to the view which is recorded, and it's right at the end of our written case, so MS 0267, in the postscript to the opinion of the Court of Session. It rather reflects the anxieties which are expressed in the debates in the Scottish Assembly, and we thought it might be helpful to this court to put them in full, and there they are in the authorities bundle, because the Scottish equivalent of the Westminster Hansard, to see what debates were, in particular at the committee stage, in arriving at legislation that is currently said to be controversial, may be helpful. But from the safeguarder's point of view, the proliferation of persons and the proliferation and dissemination of information and the stresses and strains caused by litigation of this kind not only probably tend to undermine the praiseworthy intentment behind the Scottish system, but also act contrary to the interests of children. And she has been able to form a view and advise on the benefits and disbenefits of contact by XY. So, although perhaps that might be the cart and not the horse, I don't know, in terms of the way that this court reaches decisions in these appeals, the safeguarder says firmly that the dismissal of these appeals, both in the individual case of XY with which she is concerned, and generally in respect of Scottish children, is likely also to be a decision that reflects best interests. We say, emboldened by the submissions of the principal reporter and the Lord Advocate, that it is also good law. My ladies and my lords, I think I'm right on time, but can I turn to Mr. Powell beside me and those behind me to see if I've left out anything? And to my ladies and my lords to see if I've left out anything.
I think not, Mr. Setright. Thank you very much indeed. And I gather Mr. Powell does not wish to follow. Yeah. Now.
Well, that's all right. Yeah.
Ms. Brabender has kindly ceded position, but I think that's to allow her to join us and sort her papers. My lady in the chair asked about kinship care in Scotland. There is currently a focus on kinship care in the 2014 Children and Young People Scotland Act, Section 71 and following. There was provision made for residence orders which allowed relatives to look after children to be treated as kinship care orders, although they're orders that in themselves are made under the Children's Scotland Act, Section 11. The benefit of that is a set of regulations. I can minimise this. Because accompanying the main legislation, there is the Kinship Care Assistance Scotland Order of 2016, number 153, which specifies the assistance that local authorities must give to kinship carers, and that includes financial assistance. The importance of that for the purpose of this case, and it's an importance I mentioned when I argued the case in the Inner House, is that if there is to be a kinship carer who has not previously had significant involvement in the upbringing of the child, they cannot be a relevant person. And that, of course, causes a problem. I have a few brief replies, and they are to the suggestion that being a relevant person is all about the exercise of parental rights and responsibilities. Well, so it is if you qualify under Section 200. But Section 81.3 is precisely for those people who don't qualify by virtue of having parental responsibilities and parental rights and who are not in the position of being a parent. So this is an expansion of the people who might be in the children's hearing. And listening to the debate in the course of the afternoon, when it's been suggested that in place of a direct response to the application on behalf of somebody seeking to be a relevant person under 81.3, there might be something from the back of the cupboard that can be pulled out and has indeed been pulled out since these cases started. It feels rather like boxing with flypaper because the case has changed regularly over the course of the argument, and we still have matters which we don't know whether or not they'll work. My learned junior, who, as ever, the reporter, points out that, in fact, in sections 8 and 9 of the Children's Scotland Act, it's for the national convener to provide advice to children's hearings, and in terms of section 9, nothing in this act authorises the national convener or the principal reporter to direct or guide a children's hearing and carry out the functions conferred on children's hearings by virtue of this act or any other enactment. And that indeed is discussed in the policy memorandum which Mr. Setwright has been kind enough to provide at paragraph 62.
Mrs. Scott, we don't have sections 8 and 9. If you think they're important, we've really got to have copies.
They only became important when I...
If you now think they're important, we really ought to have copies.
You will have copies.
Very well.
The policy memorandum is there. It's in Mr. Setwright's bundle at page MS 747. A quick reference to Mr. Moynihan's referral to CM against the Scottish Children's Reporters Accommodation. The parts he referred to are in part the submissions made by my learned junior who argued that case when he proposed a purposive application directed towards locus standi in paragraphs 8 and 9 of the judgment, which was rejected by the Sheriff Appeal Court in favour of the factual test based upon upbringing, which is there in paragraphs 12 and 13. He tells me it was originally an extempore decision and perhaps isn't as clear as it might otherwise have been. Turning to whether, if it be relevant to this debate, XY had difficulties in exercising the ad hoc and hodgepodge rights or possibilities that might have been accorded to him, the answer is he did. He had turned up on one occasion and not been admitted to LM's hearing, and perhaps there's good reason for that. He has turned up to AM's hearing, been brought in, asked a few questions and sent out again, rather than having any full participation. As for the suggestion that when he was unwell and didn't turn up, the children's hearing was unlawful in proceeding without him and he could have judicially reviewed it. Well, he didn't know what the decision of the hearing was because it wasn't issued to him. He would have had to apply for legal aid, and this would have been in the Court of Session in Edinburgh, not to the Sheriff in Stornoway, by which time, as Lord Roger famously said in the Principal Reporter against Kay case, the train would have left the platform. It would have long gone, because the beauty of this system is speed, and a remedy of judicial review is really of no particular use, as the Strasbourg court said in W against the United Kingdom.
Mrs. Scott, is the tally of 40 hearings, is that highly unusual?
Yes, it is, but I think that's because there were separate hearings for the three girls, in part. And I have to say that not one of those hearings was at the instigation of XY, because he was not in a position to ask for a hearing.
No, I just wanted to get an impression. It struck me as being
Yes,
very
indeed,
unusual.
indeed, yes, yes.
Thank you.
The court were concerned about the delay between a referral to the children's hearing and a decision, and that gap can be a very long gap if there is a complex grounds hearing. I think Manor Junior is dealing with one at the moment where there's likely to be well over a year. Mr. Richardson points out to me that there is helpful information in his case. I think it's at paragraph 36. Yeah, it's on MS 1805. The only other point to make is perhaps in relation to Mr. Moynihan's reference to the looked after children regulations. The part that was referred to in our submissions was the child's plan, and it's the child's plan that generally forms part of the report to the children's hearing, rather than the information which is a precursor, which is in Schedule 1 of the looked after children regulations. And then in relation to Mr. Mitchell's point on section 178, this court probably won't need me to point out that that section is drafted on the basis of Lord Mustall's decision in Re B, a minor confidentiality of reports, which is now reflected in Scottish jurisprudence, and indeed is discussed by Mr. Justice Mumby, as he was in Re B, and the President Mumby when he dealt with the case of C against C. My final point is, if one wants to take into account all these different strands, rather than the flypaper approach, in my submission, the proper legal approach is the approach of proportionality, which this court endorsed in the Bindloss case, and that allows all these various points to be brought together properly and appropriately without contravening the procedural rights of any person, without ignoring the views, without ignoring welfare. This has to be, in my submission, a proportionality exercise that carries the respect for family life inherent in Article 8 of the European Convention on Human Rights. And I hand over to Ms. Brabender for the final word.
My ladies and my lords, I will try to be as brief as I possibly can be. The 40 hearings that the court has heard about in XY, in my experience, that's an exceptional number of hearings. That is not a reflection of the average passage of a case through the children's hearing. One of the court asked what the purpose of the Who Cares report that was prepared in respect of DEF. The purpose was, if your lordships and your ladyships have regard to it, it's at MS 997 in ABC's bundle. It's a report prepared by a Who Cares worker, a Who Cares advocate, having met with DEF at school and in his placement over the course of about 3 months. I think she meets him about 6 times. And then that report is provided to the children's hearing. And in that report, the court will see how important ABC is to DEF. So when we talk about when Mr. Mitchell addresses the court and says this is all about the appellants, it's not. It's certainly in ABC, it's about both children who were before the children's hearing, and only one of them still is. I've heard nothing which justifies the approach of the children's hearings on the 7th of September 17 and 5th December 17. I make clear, if it was not already clear, that ABC does complain about what happens at those children's hearings. Those are the children's hearings that are the subject of this judicial review. Those are the hearings in which ABC says unlawful decisions were made. Whatever is now argued by the principal reporter that could happen in the future, Section 78 was not applied in the way that is now described at the hearing on the 7th of September 2017. ABC wasn't notified, he wasn't told it was happening, he turned up by accident, he was let in for a few minutes and then asked to leave. He wasn't told what the decision was, he wasn't told any of the contents of the reports. So when Mr. Moynihan says, if the chairperson doesn't let the sibling in, then it's an unanswerable judicial review. Well, here I am in the Supreme Court.
You mean to say he's conceded your case?
In respect of a hearing where he wasn't allowed in on the 7th of September. On the 5th of December, I accept that he was notified. I've taken the court to how he was notified. But again, what's relied upon now is how this system could be worked. Didn't happen on the 5th of December. The practice direction that includes practice direction number 9 about notification is September 2018, and it's now acknowledged that Rule 61 has not yet been used. Can I also just address a couple of matters which have come up? The bilingual child referred to by Mr. Moynihan as being a sibling who's been deemed a relevant person. Those instructing me also acted for that bilingual child. She was excluded from the children's hearing in respect of her little brother. She applied to be a deemed relevant person and the children's hearing refused her application. She appealed to that decision to refuse her deemed status to the sheriff. Counsel was instructed. An argument took place before the sheriff, who then deemed her to be a relevant person. Children's hearings took place in that case while the appeal process was ongoing. The deeming of that bilingual child as a relevant person can't possibly be said to have been an easy process, as described. She is one example of a sibling who has taken the route of applying to be deemed a relevant person. Can I also say that relevant persons, those who are deemed relevant persons, my learned friend Mr. Locke focused on family members, it is not uncommon for foster carers to be deemed relevant persons. Foster carers who are looking after children in terms of the CSO and have no familial connection with the child. May I also just address the case of Boyle very briefly? I don't need to take the court to Boyle. It is of some age, but even in Boyle, there was an interference with the uncle's Article 8 rights. I cannot equate the relationship between uncle and nephew who do not cohabit with the enduring relationship of siblings who grow up together in the same family. The rights that must attach to siblings and their family life with their wee brothers and sisters must be greater than that which might be preserved by an uncle-nephew relationship in broad terms. I accept there will be different particular circumstances. The relevant passages of Boyle which demonstrate the interference with his Article 8 rights are paragraphs 54 to 58 from page MS 1225. I also cannot agree that the sibling relationship is limited to the broken down element of contact, or that parents exercise a discretion as to whether or not their children see one another. Children, siblings who grow up in a family home together with each other do not seek permission from their mum and dad to go to the bedroom next door to see their wee brother or sister. So the notion that all that's happened is that discretion as to whether they get to see one another has transferred over to the local authority is one that I cannot agree with. In the early stages of a referral to a children's hearing, where it is accepted, I think, by all parties that these are unproven allegations until the grounds are accepted or established at the Sheriff Court, it is even more important to make sure that that sibling relationship is preserved, because perhaps this state intervention in that relationship is about to be brought to an end if the grounds are not established. So at that stage, before Rule 61 can even come into play, it's at that stage that the sibling has to be notified of hearings which might make an ICSO, an interim compulsory supervision order, or indeed make well, they wouldn't be able to make a compulsory supervision order, so it would be an interim one. Finally, on compatibility, I still haven't heard what the replacement for the firing gun is. If it is practice direction number 9, that is not a firing gun. That is still a discretion on the part of the reporter, and the court has heard today that where there might not be any change to contact arrangements, there wouldn't be any notification. And it would only be if the child, the sibling child, who's not before the hearing, it would only be if they raised an issue with the reporter that notification of a hearing would be sent out. Now again, if they don't know that a children's hearing is coming up, they can't tell the reporter that there is an issue about contact. So the practice direction 9 doesn't fulfil the role of the firing gun. And I have not heard any submissions about a backstop, a safeguard if it goes wrong. To use my learned friend, Mr. Moynihan's analogy, I don't want a salami, so I'm not going to slice one. But if I were to slice a relevant person, what I would want from it is a participant with rights. And the two most important rights, as we identified yesterday, being the firing gun and the backstop of an appeal or a review. Indeed, the interference in Mr. Boyle's rights as an uncle was because he didn't have the opportunity to make contributions to the decision-making or a right of review. And finally, the court's heard today about inhumanity of children being asked at children's hearings to express their deepest thoughts before a room full of people. The subject child is already asked to do that. If hearings are held together, so in this case A, B, C and D, E, F came before the children's hearing at the same time, if their hearings had been held together, they would have been expressing their innermost thoughts in front of a room full of people. We, of course, want to keep it informal. However, there is always the power within Section 76 of the 2011 Act, which is in the court's papers at MS 767 in ABC, to exclude anyone from the hearing for, if it's to allow the child to address the children's hearing. And if there is a risk of inhumanity, then that provision can be used. But I would caution the use of such expressions and the use of expressions that it doesn't do children any good to be drawn into the forensic arena. The children's hearing, the purpose of the children's hearing is child-centred. If we're going to describe that now as a forensic arena which children shouldn't be brought into, then we have bigger problems than just this. Thank you very much for allowing me to overrun to past 4 o'clock.
Well, it wasn't your fault that we went past 4 o'clock, so thank you all very much indeed. We're very grateful for all the submissions that we have heard and received, not only from those who've got to their feet, but from those who probably wrote them. We will now go away and see how we can work out.
How long are you going to give Mr. Unlop for the written material?
I just finished what I was saying.
Of course. I'm so sorry.
I'm completely off my stride. We will obviously want to have all the material which Mr. Moynihan and Ms. Dunlop have promised us, which on their case makes for the flexible approach, which will be the proper answer to this case, rather than the different approach and the different approaches which have been urged on us by the appellants. We need to have that material as soon as it can possibly be provided. No doubt a week would be more than enough for you to do it. Yes. Thank you. And once we've got it, we will try and work out what the answer is. Thank you.